You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. Hello, and our guest today is Taylor Asen. And Taylor's got a firm. They practice in 3 states up there in the northeast part of the country: Maine, New Hampshire, Vermont. And Taylor, welcome to the podcast.
That's a pleasure to be here.
Yeah, you and I had the good fortune of meeting out in California. Now I'm sitting in South Carolina. In some ways, it feels like we've got the nation covered.
We've got it under lock and key.
Yeah. Tell us about your practice there in the Northeast.
Yeah, so I have a practice called Gideon Asen with my partner Ben Gideon. I don't think he was in California with me when we met. Ben and I broke off from a larger firm here, which is about 18 lawyers, which is a pretty good sized plaintiffs firm, and by Maine standards was the biggest firm by far. And we've built a little firm of our own. We've got 7 lawyers now, and we're doing a mix of stuff, but trying to stay true to our mission, which was to do a small volume of high impact, complicated med mal and PI cases. And I tell people I wish I would have known how hard it was going to be to run my own law firm, and I probably wouldn't have done it. But the truth is, I feel very blessed. I mean, there's nothing. We have the best jobs in the world, and getting to do this for yourself is a great privilege.
And I tell people, folks will reach out to me from time to time about wanting to open a practice or wanting to switch sides over to the plaintiff side. And whenever the question about your own practice comes up, I always say it's like, look, you're going to have a lower floor, a higher ceiling, and it's wonderful if you're willing to take on the added responsibilities that come with being a firm owner or business owner. And for me, I think the biggest challenge is like the mental energy or the space, the ambient thought. Whereas when you're working for someone and your sole responsibility is working on cases, working up cases, all of it's client and case focused, when you're driving down the road, your mind may drift to expert testimony in a particular case. Whereas if you're a firm owner, your mind may drift to an expert in a case, or it may drift to making sure there's not trash in your parking lot. So it's just
Right.
you've just got
Yeah,
to.
and I think um, I became a trial lawyer in part because I wanted to take on more risk. And I mean, this is partly what I think we're going to talk about today. I think lawyers have a strange conception of risk. In some ways, we are willing to take too much, and in some ways, we're far too risk averse. And interestingly, my father was a lawyer, and when I told him I was thinking about starting this firm, I thought he was going to be discouraging and say, you have this great job, why will leave it? But what he said to me was, when I started my own firm, they had a receptionist who was on welfare, and they would go send her to hang out at the welfare office to pick up clients. And he said, you're starting in a whole different world than I started in, and what do you really have to lose? And I realized, like, the worst thing that was going to happen is we'd fail, and I'd go get a job working for Kenny Berger. I mean, it's not, it's the risk is not as big as we often act like it is, right?
And that was the way I looked at it too. It's like, all right, worst case scenario, if this doesn't work, I'll just get back and work for somebody else, and that'll be perfectly fine. It'll be okay.
It'll be okay. Yeah.
When
I
I
mean,
went
you
out,
look at what some business owners risk, and it's feels like peanuts. So
yeah. So speaking of risk, I mean that is what we're going to be talking about primarily today. And you've got some experience with big data. You've given a lot of time and thought and effort toward analyzing what a good gamble is, what a bad take is, and what some people may look at like in the gambling or sports world as like a bad beat is actually relatively predictable in some instances. So when you say lawyers may at times take on too much risk or at other times be overly risk averse. Let me give you the floor and then let's just talk about it.
Yeah, so I guess the starting place to me is the work that the Campbells have done. And I know you've had them on here before. Just to give everybody a background who doesn't know about their work, you should. They are sort of the pioneers of big data in litigation, where they are essentially using surveys, paid surveys, to um, get a more quantitative look at the quality of your case. So instead of a focus group where you're talking to 7 or 8 people, they're talking to 300 and 400 people. And what that gets you is a lot, but it doesn't get you everything. What it gets you is essentially a win rate. So how many times out of 100 you're likely to win the case, and it gets you a median value, right? And with those two things, you can calculate what gamblers call the expected value. So you can basically say, well, look, I think if this case is tried 100 times, I'm likely to win it 80 times, and I'm likely to get $1 million on average per win. So that would mean the expected value is $800,000, right? You can basically multiply the win rate by the median value. That's a little oversimplified, but more or less that's expected value. And theoretically, you should be able to say, okay, well, that's the expected value of the case. If I can get $800,000, I'll settle. If I can't, I won't. So when we first started working with the Campbells, that was sort of the way we were approaching things. Then we had a loss, quite a bad loss in a birth injury case, a very difficult case, but one where we thought we were going to win, and where we turned down $11 million and then lost. And I want to be clear when I say this changed my thinking. What happens in a case, just like what happens in a bet, should not change the way that you bet, right? That's pretty fundamental about the way statistics work. And I think the case was worth more than $11 million, had an expected value of more than $11 million, even though we lost. The problem was what we didn't think about enough is the other side of the equation, which is that just because something has an expected value doesn't that's positive, right? That's more than you're being offered. Doesn't mean you're going to get it every time, right? I mean, there are bets. Sometimes playing the lottery has a positive expected value. If there's enough money already in the lottery, right, like Powerball keeps money in there. So there are times when the Powerball is so big that a dollar bet has an expected positive value, because even though your chance of winning is exceedingly low, the amount you'll win is greater than the risk of losing, right? You're still probably going to lose, but it has a positive expected value. The point being, expected value is really a way to look at a bet when you have an infinite amount of bets you can place, right? When you're a card counter in blackjack, you have a slightly positive expected value. If you play 1,000,000 hands, you're going to win. But in trial, you only have one hand, or the client only has one hand. So it creates this problem where sometimes the right bet in terms of expected value may not be the right bet for the client because of the amount of risk the client's taking on. And so when I said we can be too risk averse and not risk, and also not take enough risk, here's the conundrum. We often settle cases below the expected value. I think many of us do settle cases significantly below the expected value, and that's a problem. On the other hand, if we're only considering expected value, we're missing part of the equation, which is what can our client afford to lose? And sometimes we make investments. I mean, if you think about the way people invest their 401k, right? They're not investing based on trying to get the most money. They're investing based on hedging risk, right? So we have to find ways to protect our clients from downside while also giving them a shot at getting the most money possible.
Okay, so Taylor, I think the natural question is when we look at what this is fascinating, by the way.
Okay, good. I can't I can't tell if it's fascinating or boring, but
Let me rephrase. It's fascinating to me.
okay.
When you and I met out in California, I was like, oh man, what a cool, interesting guy. Um,
Oh, all right.
and this guy's fun to talk to. And usually it's funny, my wife laughs about this. When it comes to parties and stuff, I'm terrible at small talk, except with other lawyers. So if there's another lawyer there, I'm like, oh, I'm good. We'll have plenty to talk about. If
He
it,
must love that.
yeah, it's her favorite thing about me. Um, but if we're going out and it's like non-lawyers and it's like, oh, how was your trip to Barcelona? I too have been to Barcelona. I'm not good
Yeah.
at it. But this kind of stuff I just think is, infinitely interesting. But going back to, all right, we've got expected value, and that there are other variables that we would want to consider in a one-off case, not in we've got 100 or 1,000 or 10,000 bets to make and we've got an edge.
Right.
Um, but we've got a one-off case. Let's talk about some of those other variables in common sense or practical terms, especially in light of a client and their needs.
Yeah. So a few things about that. I mean, obviously, we all have cases where our clients can't afford to lose, right? And I mean, what made the birth injury kit loss so painful was it was one of those cases. And then we have cases, those of us who are lucky enough to have these cases, where the client wants to go to trial. That's the most important thing. It's not the money. Um, and those are kind of the two poles, right? There's a bit of a conflict here, I think, because for us lawyers, um, we do get to play multiple hands, right? And our clients don't. They get one hand. And so we can sort of say, well, we can try cases and lose them. And over time, um, if we're taking positive EV bets, we should be succeeding. But that's not true for the individual client. And what I found so interesting is when you talk to lawyers about their risk tolerance with their own money, how much they are like normal people, meaning they tend to be too risk averse, right? There are all these cognitive biases human beings have that make us much too risk averse. So, um, one thing when I've given talks about this is I've asked people, let's say I had a die and I said to you, if I roll 1 to 4, you win. If I roll 5 or 6, you lose. 50-50, you can bet as much of your money as you want. How much money would you bet? Right. Now, any professional gambler would say that's an extraordinarily good bet, right? That's unexpected. You're going to win that bet 2/3 of the time. There is nobody in gambling who ever gets a bet that good. And they would say, you need to bet a lot of money. I mean, that's a very, very good bet, right? The most common answer I've gotten from lawyers is I'd probably bet $100. That's insane, right? I mean, if we ever had a bet that good for our clients, we would take it. So why aren't we taking it for ourselves? And the answer is because it's our money. We don't want to lose it. People don't want to lose their own money. There's an aversion bias, right? Um, but that's a problem if we're thinking about risk differently for our clients than we think about it for ourselves.
Yeah, and I never really thought, I mean, I think about the idea of, we've turned down money on cases before and lost, and not $11 million, but I mean, we had a case in a very conservative venue a few years ago. Turned down $500,000. They probably would have paid more than that. Client wanted $1 million. I totally understood. Um, I thought we were going to get a verdict over $1 million, and yeah, jury came back and finding of no on a complicated explanation of proximate cause on a verdict form. And just it happens.
Yeah.
And so I thought about kind of what it means for the client not to get the money. What I hadn't thought about as much is if there's already an offer, by saying no, we have entered that loss aversion world. I mean, we have entered that, okay, I have something that I can cash
Right.
out right now.
Right.
And now I'm trying to go for more when I could also lose everything that's being offered, to your point of we don't want to lose what we already have. And to we've had Rex Paris and other people on who've talked about how much harder we'll work to keep what we have and
Yeah.
protect. But I hadn't thought about it before in the sense of it's already there. It's already kind of being counted.
No, I think that's exactly right. And that insurance companies understand that. And that's why they're dangling the money, right? They understand the principle of loss aversion and that people, once they start to think the money's there, have a hard time not taking it, even if it's not a fair offer. And I think I don't have any answer to this problem that's particularly uh, incredible. I mean, if I did, I guess I would be living in the Spain with the Campbells. But the way I sort of thought about it is that um, we we all say we want to try more cases, and we should be trying more cases. And I think if we all tried more cases, we would realize we're not getting full value, right? And would do a lot to help us get full value. On the other hand, there's risk associated with trial that sometimes our clients, it's not good for our clients. And I've been reading a lot of another lawyer recommended to me this guy Nassim Taleb. I don't or Taleb. I don't know if you know him. He
I do.
he wrote the Black Swan book, and he writes a lot about risk. And he wrote a series of books. That's 4 books. I can't recall what they're all called, but there's Black Swan is the most famous. And do you know the concept of a black swan? So he had this idea that essentially
Then I've
a black swan. The idea is it's something that no what changes the world and really moves history are things we're not contemplating. So it's called the black swan because people used to believe there were no black swans; there were only white swans, and because they had never seen a black swan. But then when we discovered, I think Australia or that part of the world, people saw a black swan for the first time. So his point is there's just a huge amount about the world we don't know, and history is sort of shaped by things we don't understand, and that's why risk is really a lot different than we think, right? And if you look at the housing crisis in 2008 or any of these crises, it's sort of always the same story through his mind, which is people sort of draw conclusions based on limited information and then end up being humbled. But what this all leads to for Taleb is this idea of barbell investing, that his argument is smart investors, and he was an investor who basically invested in risk. And his argument is what we do a lot is we invest in medium risk, but that's stupid, essentially. And that what we should be doing is investing in extremely safe bets, like he would say treasury bonds, right? Something that's essentially unassailable. And then very, very high risk bets, because the high risk bets are where the big gains come in. And pairing those is like a barbell, right? You pair very low risk with high risk. And what I started thinking is that's basically what we can do that in trial. And the way we do that is by hedging. It's just hedging, basically, but settling part of the case, right? High-low agreements. Interestingly, I think non-recourse loans is a way to do it. Now, I've talked to non-recourse loan companies about this. They don't like the idea that they're a hedge, and they don't loan enough money to make it work. But really, that's what they are, right? I mean, your client can get $100,000. You're going to pay a very high rate on it, but at least the client knows they're not going to walk away with nothing, right? That's a hedge. And what's interesting is lawyers are so averse to the idea of hedging, and I don't know why. I mean, so many lawyers think high-low agreements are essentially, you might as well like play in the sandbox with little kids because no real man would do a high-low agreement. But it's just a hedge, right? It's a way to capture upside while protecting your client from downside, which is what we probably should be doing. And if we were willing to hedge more, we could try more cases and get better results. So that's what I'm trying to do, a lot more than that of that. I'm trying to settle out with one defendant, keep the rest in. And there's penalties you pay for that. Obviously, it makes the trial harder. But I think in the long run, it's still a better move.
I like this barbell
It's
concept.
interesting, right?
I also like, I mean, speaking of black swans and being humbled by the things that we don't know. I mean, I think about that case I was telling you about, where we turned down a good bit of money, it got poured out. We didn't know that there was going to be a guy named Jimmy who moved from upstate New York to South Carolina to Lexington County, which is the buckle, or one of the buckles of a Bible Belt. Um, Very, very conservative. Not that you can't get a good verdict there. Some really good verdicts have come out of there. But anyways, this guy Jimmy moves down from upstate New York to Lexington because upstate New York just wasn't conservative or American enough for him. And we don't have meaningful voir dire in South Carolina. We're one
This
of,
guy was on your jury,
so
Jimmy.
we just say it again.
He was on your jury.
Yeah, he sneaks on the jury.
Yeah.
After the trial, we find out that Jimmy, who we nicknamed Jimmy the Justice Killer, Jimmy just started raising all types of hell, and just, man, getting after it. And he told us how thankful he was to be on the jury. He'd always wanted to do this. He was really hoping he got picked. He'd watched a lot of TV, and he just felt like this was his turn, to protect folks from lawsuits. And we did not know he was going to be there. So when we were looking at money and what to turn down and what to take, had we known this individual on this jury for this case, we approach it differently. And to your point, we probably do push for a high low.
Well,
Um,
that's exactly the problem. And there's an absurdity about the way we all talk about value, and it's apparent to you when you're a young lawyer, and then you forget the absurdity of it, and we should all remember it. We all sit around talking about value like we know what the answer is, right? Like this case is worth $50,000. This case is worth $1 million. We all have no idea what any of these cases are worth. And with data, we can get a median, right? We can say, well, if the case is tried 100 times, here's what it's worth, and that may matter. But if you ever do one of these Campbell studies and you look at non-economic damages, what you'll see is, I mean, the one I just did, which was a death case involving a young woman who died from a blood clot. It's a pharmacy malpractice case. There were jurors who put pre-death pain and suffering at $500,000, and there were jurors who put it at $50 million, right? Those are all, the way life works is not, in real life, we don't just average things out. Those are real people who could be on your jury, right? And the idea that and that's a huge unknown, right? I mean, we can think by asking them these questions, we know what they're going to do, but we don't. In the case we lost that I was telling you about, what was interesting is, and even more heartbreaking, so we thought, what we were told by the data was we had about a 75% win rate. It turns out that was pretty close, because in the initial vote, 10 out of the 12 jurors were with us. It was in New Hampshire, where you need a unanimous jury. And we had some justice killers on that jury who talked the other 10 people into their position.
yeah,
Bad
you
luck.
had I mean, hell, you beat the average on win rate.
Right,
It's 9 out of 12. You get 10 out of 12. So I mean, it's
right.
spot on there. The problem, to your point, is your win rate was 75%, not 100% for.
Exactly.
I mean, whenever we've worked with the Campbells, whenever we've worked with folks here, we got a great lawyer down here named Dirk Derrick who's doing some really cool stuff in the focus group space. It's always, always, always helpful. And it's one more, data point, if you will, with a lot of data points. And at the same time, until you get those six, those eight, those 10, or for us, we're 12 unanimous in state court, until you get those 12, you just don't know. Let me ask you this, Taylor. I've got a good friend named Liam Duffy, great lawyer down here too. He's doing some really cool stuff with AI and has been working with AI and focus groups, kind of using on demographics and extrapolating out with larger and larger kind of AI artificial data sets.
Yeah,
Have you worked at all in that world and see anything that factors into risk calculation?
I haven't. I've been reading. I've seen online that people are playing with this, and um, I mean, it makes perfect sense to me. AI, as far as I understand it, which is not very well, but I think probably as well as anybody, is basically just a rehashing of what a lot of people have said, right? I mean, that's what AI does. So it makes sense to me that with AI, you should be able to get sort of like um, a survey like response. But I also um, and we do use AI in our firm to some extent. I also feel like sometimes with AI, the results are overstated by people who use it. You know, we've tried to do some medical record stuff with AI, and I mean, it's impressive, but it's not there yet. I don't think in terms of the quality that I was hoping. But I mean, it would be great to be able to do this kind of data work that wasn't so expensive. I mean, working with the Campbells is not cheap. Um, we've also done some of it ourselves, just using like SurveyMonkey. You can use SurveyMonkey to create your own surveys and very inexpensively hire. There are people who apparently just spend their days taking surveys online. Now, of course, you'd think there would be a sort of bias there that, you know, we're getting all these people who just sit around taking surveys, but they all have different demographic. You can get different demographics of people. Um, and I don't know how the Campbells find their people, but I'm assuming that's how they do it as well. There are websites where you can just hire people for a few bucks to take a survey. And for a few $100s, you can get a bunch of data on your case. So for people who don't want to invest, you know, $25 to $30,000 in a data study, you should feel free to email me and I can send you the stuff we've been playing around with. You know, we don't have an economist who works with us to make sure it's statistically significant and all that, but you can get a gist of how good your case is, and you get feedback from jurors about concerns they have, and um, it's useful data.
Taylor, let's also talk about some of the books you've read or books that you are reading that help lawyers and really everybody understand risk and ultimately gambling better.
Yeah, so there's a few I'd recommend. One is, as I said, the Nassim Taleb books, um, Black Swan. Um, I forget the name of the one where he introduces the idea of the barbell, but there's four of these books. They're irreverent and fun and worth listening to or reading. Um, Nate Silver has a great book called On the Edge. Nate Silver, for people who aren't political junkies, is the guy who came up with 538. And he's basically also a professional gambler, and that's really worth reading. And then there's a book by a professional poker player named Annie Dukes called Thinking in Bets. That's really wonderful. I mean, she's written a few books. I mean, one of the main points she makes is that this point I made before about that you shouldn't draw conclusions from losses or from wins, right? You should, because you could make the right bet and lose, and you can learn the wrong conclusion from that, which is that you shouldn't have made that bet. But sometimes you make the right bet and you lose. So those are some books I would definitely recommend if you're interested in risk.
And I mean, one of the most profound things that you've mentioned, and it's simple, and again, there was a time where we knew it, and then in the daily practice of law, I think I overlook it, but it's the client has one shot. We have many, many, many shots. And so, we always have to be cognizant, obviously, of kind of the underlying potential for for conflict there and a divergence of interest, and then putting that interest aside and upholding ourselves as fiduciaries and zealous advocates and putting whatever is in the absolute best interest of the client first, um, and doing that always. Once they're informed. You know what, Tara? This would be interesting. I've seen it happen in both directions. Where lawyer will say, "Ah, the client wanted to take it," or lawyer will say, "Ah, the client wanted a trial," and really what they're saying is, "I convinced the client to take it," or "I can."
Of course, yeah, yeah, and that's the you know look, that's the problem is these lessons can cut both ways. I mean, on the one hand, you have to be responsible and not take a risk that could devastate your client. On the other hand, it's very easy as a lawyer when you have bigger cases, you have a serious catastrophic case, you settle it for $2 million, and you tell yourself, well, I'm a hero, right? Then you see that Joe Freed settled the exact same case for $65 trillion, right? It's like, well, maybe I'm not the hero I thought I was. And um, you know, those two sides are in tension. I mean, are you settling too soon and are you being too aggressive? The only way I've figured out how to solve it is through hedging. Unless you have a case where you essentially know you're going to get a win, and unfortunately, I don't get many of those cases. As I said before, most of what I do is med mal. You could have the most egregious med mal case in the world, and you're not going to be assured of anything.
So,
Um,
Taylor, speaking of med mal, I mean, how do you all go about, because med mal cases are so time intensive and so expensive. How do you go about on the front end without full knowledge of the facts, without the opportunity to fully develop the legal case? How do you all go about making decisions on what's worth the risk in terms of time and money investment, and where you need to pass?
Oh, that's a big question, and it's a hard one, and we're constantly refining it. We now have a lawyer at my firm who most of what he does is talk to potentials. And the last time I looked, we were looking at about 1 out of 10 med mal cases. So by looking at, I mean, we'll get the records or the client will get the records and we'll review them. Of those, about 1 out of 10 becomes a case. So we're somewhere in the area of 1 out of 100. Um, but we do it in stages. So we look at the records. If we can't rule it out, we then will hire an expert to look at the most difficult issue first, right? The idea being, well, if we can't prove causation here, we know we probably have a negligence here, but let's look at causation first because it's harder, right? Trying to figure out ways to rule out the case aggressively. And I try to work with experts who are honest, and that we all have had this experience of experts telling us what we want to hear. When an expert tells me I don't have a case, I always try to say thank you. As painful as it is, no one wants to hear that. But in MedMal, if you've had the experience of litigating a case for a couple of years and then figuring out you didn't have a case, that is an immensely painful and costly mistake. So having an expert who early on can tell you don't do this, that's a really big gift.
Now, I like the idea of, like you said, staging it out. Maybe 1 in 10 make it through to the second criterion, and or the second stage in the case, and then one
And
of
the first trial lawyer I worked with always said to me, under promise and over perform. And I think about that all the time. And I try to tell potential clients, look, we're going to look at your case, but I just want you to know most cases we look at, we don't take because people, people are so desperate who we speak to. And I mean, they're in awful situations. They want to believe they have a case and they're going to take any breadcrumbs you give them as a sign they have a case unless you tell them otherwise. And it just makes breaking up a lot more painful when you haven't been upfront.
yeah. I mean, I got the reminder fairly recently. I can't remember who mentioned it, but that basically, the point was, if you mention a range to a client, they hear the higher number.
Right.
Range
Right.
to defense lawyer,
Yeah.
insurance adjuster, they hear the lower number.
And right. And the client hears the higher number and has already started spending it in their mind. Yeah.
And that's and that's what they're netting. I mean, it's like
Right, right.
well, Taylor, I think the folks who are doing some landscaping outside our office are giving us the cue that we've had a great episode, and it's time to let you get back to calculating risk and making good decisions on behalf of clients. For folks who want to get in touch with you, either about this topic, about a medical malpractice case, or really about any case of real significance in Vermont, New Hampshire, Maine, what's the best way for them to do that?
Probably by email at tasen@gideonasenlaw.com. I'm happy to work with people, but I love talking about this stuff like you do. So if you have any questions or comments, or you figured something out I haven't, give me a shout.
Nice, man. Listen, Taylor, thank you so much
Thanks, guys.
for everyone who's listened today. Again, our guest today has been Taylor Asen, and he's at Gideon Asen, one of the premier firms in the northeastern part of the country. And he's just an awesome dude and a great all around guy, and super fun to talk to if you get invited to a really cool party in Newport Beach. So, with
That's
that,
right.
thank everybody for listening today, and we'll do it again soon. And Taylor, thank you for being on.
Yeah, man. I'll talk to you soon.